Good morning and welcome. I'm Ben Olinsky, Senior Vice President of Structural Reform and Governance at the Center for American Progress. I want to thank you all for joining us online for this event, previewing the end of this year's Supreme Court term. I think it's probably been a while since Americans have been getting so much news and been so interested in the outcomes of a range of consequential cases being heard by the courts. Whether it's about birthright citizenship, bringing Mr. Abrego Garcia home, DOJ's efforts to access your Social Security data, or mass layoffs of public servants, there's a lot riding on the courts right now. Some of these cases are already up at the Supreme Court, others are making their way there. And none of these are even the significant cases on the Supreme Court's standard docket. Americans seem to have a newfound interest in questions around our nation's rule of law. What does it even mean? Can a president just ignore an order of the Supreme Court, of a circuit court or lower court? What can the courts do to enforce their orders, and will it be enough? Are we in a constitutional crisis? These are the right questions to be asking, and I hope this uptick in interest will also extend to some of the other cases we'll be seeing decisions in soon. Because as it turns out, it's these normal cases that can really rewrite our national politics as well, alter or even remove the checks and balances that the Constitution has set out, and claw back rights that have been long cherished. They can even yank away funding from the public schools in our communities. And you don't have to look back more than just the last few years to see this play out. In Trump v. US, the far-right majority on the Supreme Court effectively rewrote the Constitution summarily to grant presidents immunity for most things they do while in office, even if they're otherwise crimes. It also said the president had the power to tell the Department of Justice who to investigate and who to prosecute. Fast forward a little less than a year, and that decision has directly supercharged efforts by the Trump administration to break down any independence for the Department of Justice, weaponizing our nation's law enforcement to go after political enemies. It was more than striking to see the president standing at Main Justice, calling out perceived enemies by name and giving what felt like a campaign speech. Similarly, this term, the Supreme Court will be deciding cases that could for the first time allow taxpayer dollars to be siphoned out of public schools and directly fund religious education in charter schools. Let's pause there just for a minute. It means that public charter schools could be religious schools, seemingly violating the First Amendment's religious establishment clause. Beyond eroding the right to a separation of church and state, which protects each from the other, this one decision could upend our entire system of public education. Other cases will have significant impact on the rights of transgender Americans to receive the health care they need, potentially allowing the government to discriminate by blocking hormone therapy or puberty blockers for them while allowing them to go to other minors. And I want to leave you with this thought. If even the extreme right-wing majority on today's Supreme Court is beginning to push back on the Trump administration in 7-2 or even 9-0 unanimous rulings, then the administration must be doing really dangerous things, especially if the same majority is ready to take an axe to the separation of church and state and empower government to discriminate after it has already overturned Roe, eroded voting rights, and given presidents nearly unchecked immunity. We are fast approaching a watershed moment in our nation's rule of law, with the Trump administration trying to obliterate any checks and balances that exist on the president's powers. Pretty soon, the 9 souls who sit in judgment will have to decide which they want to put first: party and ideology, or a system of reason, of rules and laws that have served our nation well, and soon they will need to stand up and be counted. Without further ado, I'll turn this over to my friend and colleague Devin Ambres, CAB's Senior Director for Courts and Legal Policy, who will introduce our panel and serve as its moderator. Over to you.
Thank you, Ben, for setting the stage for our discussion on the importance of the court serving as a constitutional check and balance against unconstitutional acts by the other branches of government, and what will be coming down from the Supreme Court in the coming weeks. And thank you to everybody who has joined us today for what should be an enlightening and potentially frightening discussion. A quick bit of housekeeping. Members of the audience can submit questions through the Q&A chat function, and we will get to those in the last 15 minutes. So first, let me introduce our tremendous panelists, if you will all join us now. First up, Kimberly Atkins-Storr, senior opinion writer and columnist for the Boston Globe, and podcast host par excellence of Justice by Design, and the co-host of Sisters in Law. Next, Sam Ames, who is the former chief of staff for the Department of Education Office for Civil Rights, and presently the founder of Threshold Strategies. And last but certainly not least, Emily Chertoff, associate professor of law at the Georgetown University Law Center. Thank you all for joining us and sharing your expertise with us. And let's jump right in. I think Ben set the stage well, and I want to discuss right off the arguments in the Birthright Citizenship case that happened last Thursday and the 7-2 opinion that came down in the Alien Enemies Act cases, because they're very much intertwined. At oral argument in the Birthright case, Trump versus Casa, the justices appeared to search for a way to limit nationwide injunctions. But the following day in AARP, the Alien Enemies Act case, they granted an injunction to prevent removals under invocation of that law to everyone it could affect prior to class certification. And that's a lot of legal jargon there. But the short is, we might not have nationwide injunctions, yet the Supreme Court is granting a very broad class action the next day. And so I have kind of a compound question for you guys. And what would the real world effects on people across the country be, not just in the context of immigration, but if the Supreme Court accepts a so-called modest proposal from the administration to limit nationwide injunctions, especially as we see this administration engaging what appear to be illegal and unconstitutional acts against broad swaths of the populace? And then part two, if the court gives this power away, what can they do? What can Congress do? And what can everyday Americans do to rein in these presidential abuses of power? Let me start off with Kimberly.
Yeah, well, thank you so much for having me, Devin, and everyone there at the center. So, yes, I think listening to oral arguments in the case, the Birthright Citizenship case that was really primarily about nationwide injunctions, it seemed to me, my first thought is, wow, what a terrible set of facts, what a terrible case to try to limit nationwide injunctions, right? Because it seems so clear as all of the justices across the board nearly were really wrangling with, well, sometimes when something is happening and you have a broad and unnamed group of people who could be irreparably affected, maybe we should have the ability, and lower court should have the ability to do something to put that on hold while this is carried out. And I can't think of a more apt case than that, than the issue of birthright citizenship, where babies are being born in the United States under a more than 127 years of history that says those children are American from the point of birth. They need to have their birth certificates and other documents in place. They may need to access some sort of federal benefit, and that can't happen at all if there is uncertainty in this case. And so maybe the best idea is to keep that on hold until you figure out the constitutionality of it. That seems logical, but this is the very case that the Supreme Court is wrangling with, this issue of nationwide injunctions. I should say, let's be clear, nationwide injunctions, the lack of clear standard for them is an issue. It's a problem. It's something that has bipartisan concern, and it should be. But that is something for Congress to address, not the US Supreme Court, and certainly not in a way that could deny the ability of people to be granted something so foundational to their ability to live in America and have the American dream. So I think they, during oral arguments, kind of saw the pretzel they'd twisted themselves into. I'm hoping that they don't do harm here. But I think just the fact that nationwide injunctions could be limited in some way in the future isn't in itself a harm, but how it's done, which is the big question, right, could be.
Fair. Emily.
So I largely agree with Kimberly's analysis, certainly of what they were grappling with in the oral argument. When we're talking about the real world effects of this case, I do think one thing that's worth highlighting is how the court may be thinking the administration will react to nationwide injunctions issued by lower court judges ultimately, and how it's going to treat the Supreme Court is. And that may be weighing into their calculus as they think about how to address this issue. So to be a little bit more specific, we all know that ultimately it's the executive branch that has the power to comply or not comply with a court order, right? They control the marshals, they're the ones with the power of coercion. And various administration officials have alluded both to the idea that they might not comply with court orders and to the idea that the Supreme Court and its decisions have a different status or a different weight than the decisions of a district court judge. So when the court is thinking about nationwide injunctions versus this idea that they can kind of certify a putative class through their all writs act power, one thing that they may be thinking about is the idea that ultimately the administration may not want to comply with nationwide injunctions. And there's been a lot of concern on the court about this, so I'm not suggesting that this is the first time that they've considered cabining the nationwide injunction power of district court judges. Is obviously a long history of these injunctions being used against presidents of both parties. And I think that there's kind of bipartisan discomfort on the court with that. But there's also, I think, maybe a sense that given where we are now, you could have lower courts issuing injunctions and the administration might not comply. And so they may want to kind of come up with a procedural workaround where they grant themselves more power at these early stages when we have these emergency applications to say, hey, we're the ones who are going to decide if there's a putative class here that we're going to protect, versus leaving those decisions to district court judges whom the administration might not even listen to. So I do think, I don't want to necessarily ascribe it all to the current situation that we're in, but I think this is the court that thinks a lot about how to conserve its own power and its own institutional standing. And that may also be a factor, both in how they're thinking about the Birthright Citizenship case and in how the recent Alien Enemies Act order came out.
That's fair. I appreciate that you brought up judicial power. I think that was a big theme in what we saw them do last year when they overturned Chevron and when they accrued so much power away from the executive to themselves. And it plays very much into the concept of judicial supremacy, which Chief Justice Roberts seems to very much enjoy, even more so than the concept of a unitary executive. At some point, if we have time, I'd like to discuss maybe some of the reforms that we could see beyond judge shopping, 3-panel judges for these types of nationwide injunctions. But I don't want to give short shrift to Sam. So Sam, if you could jump in and maybe talk about beyond the context of immigration, what we would see with a broader context of application or inability to receive a nationwide injunction for other folks.
Yeah, I absolutely agree with Kimberly and Emily on the analysis of the court's thinking right now. On your question about how we sort of practically rein in the abuses of executive power, I think we're actually seeing an interesting version of this in the state context right now in Texas, in a case called PFLAG v. Abbott. A few years ago, the governor sent a letter to the State Department of Children and Families to investigate parents who supported their trans kids getting gender-affirming care for child abuse. And lawyers at Lambda and the ACLU immediately sued. They got injunctions on the Texas policy. It's in respect to the plaintiffs only. But they really wisely made one of the plaintiffs PFLAG, which anyone in the state can join. So I think it's important to remember that even if nationwide injunctions are eliminated as a way of reining in executive power, strategies do exist for advocates who are trying to defend the rights of people the government is going after in court.
Fair. And I think it's worth noting that the court didn't even talk about associational standing for larger classes and who that can affect, because the United States Chamber of Commerce wrote a very interesting amicus brief trying to support associational standing so that we can have that exact kind of defense that you just discussed. So I think that's important to note. I appreciate all your input there. I want to kind of broaden this out because we can talk about the shadow docket all day, but there are a lot of cases on the regular docket, on the merits docket. So, differentiating from the past few terms, I don't think there have been a really unifying theme that garnered public interest, like the Dobbs decision, like Loper Bright, but there are so many significant cases coming down. And I'd like each of you to touch just briefly on a couple of the cases that you're really following. Merits is great, shadow even better. But we'll go, I guess, now in reverse order. Sam, do you want to kick off here?
Sure, I will kick off. Surprising no one from that last answer, probably the big case I am watching is US v. Scrimetti, which is going to have just enormous impacts on whether a state can strip gender affirming care from trans youth, and also really possibly trans people more generally, which could have really big implications for case law around sex discrimination more generally. I'm also watching AGTV Aseo area schools, which could set a pretty extremely high nationwide standard for students with disabilities to prove discrimination that no other classes of people with disabilities to do. And then, of course, there are these big religious freedom cases, which I know we're going to touch on a bit. The one I am really watching is Mahmoud v. Taylor, their handling of school curriculum and parental opt-out options based on religious objections, which I know we're going to get into a little bit later today.
Emily?
For me, as an immigration scholar, my focus is all on the shadow docket and what's happening with emergency orders. And I think one of the most interesting things we may see this term and in future terms as these cases continue to percolate and the administration continues to take these wild policy swings on immigration is the difference between how different groups of immigrants and different issues are treated. So I'm thinking of the contrast between the order that we just had in the Alien Enemies Act case, the kind of tenor of the oral argument on the birthright citizenship issue, comparing that to something like the National PPS Alliance case, where the Supreme Court just allowed the administration to go forward stripping PPS for Venezuelan holders of temporary protected status. And so I think what you may wind up seeing as this term continues and a kind of a future terms, come into view, you may see a distinction, an even firmer distinction than we already have between the rights that citizens and non-citizens have. It's worth keeping in mind that there is a valence, both the Alien Enemies Act case and the Birthright Citizenship case, that involves citizens, because there are concerns that citizens could be deported, under the kind of Alien Enemies Act proceedings, because there aren't really any procedural checks on that. And also, obviously, birthright citizenship implicates people now who have an expectation of citizenship who may not be able to access it. So there may be more of a distinction between citizens and non-citizens and how the court is treating them. And you may also see kind of like different categories of fundamental rights being delineated, right? And the idea that the Supreme Court is saying, well, in certain cases, the rights here are really critical, so we're going to act in a different way, versus when you have something like PPS, we're not going to treat those rights, even if they are constitutional rights on some level, as implicating kind of the same concern.
Yeah,
Yeah.
and
I'm sorry. I was just going to say, and I think it's important to keep in mind how these all interplay as we're looking at birthright citizenship, because people here on TPS status, their children, many of them have been here for years. Their children are American citizens, yet they're losing any legal status that they have and potentially some rights. And we also need to keep in mind, I think the court was great in 9-0 saying due process is critical. But what happens when we start getting American citizens swept up in this and they start expanding a lack of due process? So thanks. And sorry for cutting you off, Kimberly. I apologize.
No, Devin, I stepped on you. I apologize for that. I am watching for all of those cases too. Just a couple another area I will say I am looking very closely at is what happens to discrimination claims kind of writ large, and how the complexion of those and the legal justifications may change. One area I am looking is how religious discrimination seems to be the new hot way to attack policies that people disagree with, in terms of things like the cases challenging LGBTQ rights to other people. The case that we will touch on about books featuring LGBTQ content in schools, that is seen not as an educational tool or a way to have representation in a classroom, which is very important to students and their families, but instead as some sort of affront against people who have religious views that LGBTQ people, that are against LGBTQ people, sort of more broadly. Also looking at the reverse discrimination cases, there's one that involves a woman who was fired and claimed that she was fired because she was not a lesbian, and that her boss was a lesbian, and a lesbian or a gay person was installed to replace her. That was form of reverse discrimination that's pending before the court, and also the never-ending saga over Louisiana's district maps, where initially the Black residents who were being packed into a single district instead of being allowed to have a say in two. Now you have and I'm describing how they describe themselves in the pleadings, the non-African Americans in Louisiana are now suing, saying, no, now they are being discriminated against because there are two Black opportunity districts in Louisiana after this redistricting. Actually, the state itself, it's interesting. The state's sort of like saying uncle, like, right? We were told that we were breaking, that we were unconstitutional with the first drafting. Now we're told it's unconstitutional to create this other thing. Supreme Court, just fix it. Like, we don't know what to do in that case. So I am looking more broadly at the rise of redefining what discrimination suits are, and really a diversion from the history of these laws, that these discrimination laws were set. It was discrimination against underrepresented, marginalized people, but sort of being turned to use to protect white people who don't have those sort of disadvantages.
That's fair. I think folks are taking students for fair admission and running as far as they can with it. And we can get into that a little bit down the line. One of the cases, Kimberly, that you didn't touch on that I think is critical and that we're seeing, and I hate to use the word percolating because it's all that the Solicitor General used last week during oral argument, and it's now just become the zeitgeist. But one of the shadow docket cases, Wilcox versus Trump, which deals with Trump's efforts to fire independent agency commissioners and overturn a 90-year-old case called Humphrey's Executor, which prohibits the president from firing independent agency heads. I can't remember if it was last week or yesterday. I think yesterday. President Trump fired Richard Trumka, one of the commissioners on the Consumer Product Safety Commission, a week after he voted for an effort to try and make safer lithium-ion batteries that have been burning down houses and whole apartment buildings. So could you give us kind of an overview of what these attacks on independent agency heads tell us about Trump's view of presidential power and what the negative effects of overturning this case will have on everyday Americans? Because it's really important to note that all of this is not just legal arcana. If the presidents have the authority to fire agency heads on a whim, there are real world impacts that can severely harm Americans.
Yeah, that's exactly right, Devin. You know, I am an administrative law nerd. I always have been since law school. And this case would be really delightfully nerdy if it weren't for the really, really dangerous implications of it, and how it can affect real people. So the Supreme Court in the shadow docket case has the ability to upend a nearly centuries old case called Humphrey's Executor. This dates back to the Roosevelt administration, FDR, who, in an effort to put through his New Deal policies, fired his political adversaries. And one of them was someone named William Humphrey, who was a member of the Federal Trade Commission, and who was very anti-New Deal. So the president said, look, he didn't say anything. He just asked for his resignation. But it was clear why, for the reasons that I just said. And Humphrey said, no, I'm not going to give you my resignation because I still have 5 years. I'm Senate confirmed. I still have 5 years left in my term. And this is an independent agency. And ultimately, the Supreme Court sided with Humphrey and said, no, the statute said what it said. And under the statute, presidents could only fire FTC members of the FTC board for inefficiency, neglect of duty, or malfeasance. And it's really set the cornerstone for what an independent agency is. It differs from other federal agencies that are right under, clearly within the executive branch only. Some of them are quasi-legislative, some are quasi-judicial. But in this case, this was a quasi-legislative body, the court ruled, because the statute set it up to make rules and to have some of the powers that Congress delegated to it to carry out. Now, independent agencies are really important because they are often in place to protect Americans, protect their safety, protect them from things like fraud. That's why you currently have things like the National Labor Relations Board and the National Merit Protection Board, Merit Systems Protection Board, two members that were fired by President Trump and who are now bringing this action, basically making the same argument that Humphrey did nearly a century ago. But the Supreme Court, in this case, in putting their a lower court, I should say, reinstated them and said, yeah, they were improperly fired by the president. Well, the Supreme Court put that on hold, and in a way, I think that that is ball game, because it would have been really easy for the Supreme Court to have said nothing, to have done nothing, and to let this play out in the lower courts. But the fact that they stepped in to put this on hold, and it has now been over a month since they've done so, and we're waiting for them to say something about it, I think means that there is an appetite among the majority to, if not overturn Humphrey's executive entirely, which I think would be wild to do on the shadow docket, restrict it in a way that still broadens presidential power so much as to be really, really dangerous and take away the ability of independent folks who are there not for political purposes. I'm not saying that every appointee is non-political, of course, but you need to have a group of folks, particularly in these agencies often operate with boards, like multiple members at the top, and for them to deliberate and come to the best determination of how to keep banks from overcharging people, how to keep the products that our families use safe, how to ensure that people aren't just fired on a whim for political reasons in violation of a statute. You need those people there to do that. And if those guardrails are taken away, and you have a president such as the current one who seems, in my opinion, I am an opinion columnist, bent on retribution and vengeance, and running over anybody who stands in the way of his agenda, including courts, I think that that is a step in the wrong direction. I also think it'll be really harmful to the court itself. We talked a little bit about the court's own power. I think the more power that the court delegates to the executive, the more it undermines its own power. So I'm hoping that the Supreme Court does not go down too far, this road too far, but it seems that that's the road that they're currently on.
So just a quick note, some of the independent agencies, Securities Exchange Commission, the Federal Elections Commission, the Election Assistance Commission, National Labor Relations Board, the Consumer Product Safety Commission, and the big bad in the room, the Federal Reserve. And we've already heard President Trump making noise about firing Jay Powell, who seems to be the only one who's keeping the economy on the rails at the moment. So that's really concerning. But you mentioned it would be wild for them to overturn this on the shadow docket. Do you think there's a chance that they might try and notice it for merits argument and kick it to next term? Or do you think we're going to see something at the end of June and the first week of July, we're all going to be running around with our hair on fire?
Devin, this is a question that I was actually texting some people who I know before this to say, is there a chance that they kick it to next term and, just allow full briefing and argument and give it the full treatment? And basically what they said to me was what I said. It's like, well, I think if they were going to do that, there was plenty of time for them to have put it on the merits docket for this term on an expedited basis, but they chose not to do that. So we think what most likely has happened is that the majority came to some conclusion on the shadow docket, possibly very likely limiting Humphreys to some extent, and we are waiting for the dissent and maybe concurrence writers to finish up, which is why, even though this day was put in place, I believe on the 9th of April, here we are on the 21st of May, and it's still, we still haven't heard from them.
I would love a Supreme Court term where things weren't insane and I could just take the week of July 4th off to recharge. It's not in our cards anymore. I appreciate your candor, Kimberly. Sam, I wanted to turn to you, and you had touched on Scrimeti dealing with the Tennessee prohibition on providing certain forms of gender-affirming care to minors, and the conservative justice seem ready to and willing to uphold the ban. Can you give us your thoughts on what may come down from the court, what the least bad outcome could be, and whether this could set a precedent for the ability of other states to limit other types of care that individuals receive, not just in gender care cases, but just really anything else, especially in conjunction with the way that we're seeing religion coming up as a sword less than as a shield.
Ooh, Devin, with the least bad outcome. You're not wrong. A little bit of quick background. In the last few years, literally hundreds of bills have been introduced to ban gender-affirming care for minors. They've passed in 27 states. If you can't think of a single other issue for which hundreds of bills have suddenly been introduced, you are not alone. This isn't really trans kids, right? It's a national electoral strategy written by think tanks. No offense to CAP. But they have identified trans kids as something that engages conservative religious voters. So Skrmetti is one of the 17 lawsuits that is challenging this based on two grounds, one before the court. Due process, drawing on parents' fundamental rights, and equal protection, drawing on discrimination on the basis of either sex or trans identity. The question is really going to come down to what level of scrutiny the court applies. So when the government's accused of violating equal protection, courts use three basic levels of scrutiny to look at that law: strict, intermediate, or rational basis review. And it essentially comes down to sort of how nervous we are inclined to be about the government treating someone different based on a given characteristic. Even decades into the case law applying this to LGBTQ people, we don't really know where LGBTQ people fit into this. The court has taken up several cases about us, but have managed to sort of squirm out of identifying a standard every time. They might not be able to do that this time. The government is arguing that this is not a classification based on sex at all. It's a classification based on medical purpose. So it's going to turn entirely on this question, on two sub-questions. Can they establish that discrimination against trans people is a form of sex discrimination because it bans a particular treatment like testosterone therapy for people assigned female at birth, but allows it for people assigned male at birth? If so, they will get intermediate scrutiny. Or can they establish that trans people are themselves a new quasi-suspect class, in which case they'll get, we have no idea, but something probably more than rational basis. The court hasn't created any new quasi-suspect classes in decades. During oral argument, interestingly, Justice Barrett actually seemed kind of interested in one of the factors in creating a new one, which is political powerlessness. The oral arguments took place in fall, so before the current administration took office, but whoever is writing this opinion right now, boy, do I hope that they are watching the news, because there has been an enormous amount of development when it comes to political powerlessness. But to answer your question, if the plaintiffs can't convince the court that this law deserves heightened scrutiny in some way on any of those grounds, it is possible that they could do some very bad things that extend beyond this. So they could declare a sort of medical exception to protection from sex discrimination, or really from any discrimination. Justice Jackson was particularly nervous about this at oral argument. She really flagged that she felt like this was signaling a willingness to chip away at the actual foundation of equal protection law by creating these exceptions. It could also affirmatively hold that laws discriminating against trans people, or even all LGBTQ people, are only subject to that lowest level of scrutiny, only subject to rational basis. Probably the least bad of the bad outcomes is that the court rules that discrimination against trans people doesn't fit into either framework, but again sidesteps this question of what level of scrutiny it does get. And we can hope that maybe when we return to that, it is a different looking court. I think that the wild cards here actually are sort of Barrett and Gorsuch, who don't often come together as wild cards. Gorsuch authored the opinion in Bostock v. Clayton County back in 2020, which in the context of statutory non-discrimination law ruled that sex does include gender identity. He also a little bit sidestepped the question of how, whether it's sex discrimination per se or sex stereotypes, or in the case of sexual orientation, associational discrimination. He just said it's impossible to discriminate against someone for being LGBTQ without discriminating against them based on sex. He also, at oral argument for Skrmetti, was the only justice who didn't ask a single question. Even Thomas was active. So we really have no idea where he is thinking. And then there's this other factor sort of floating around in the ether, which is parents' rights under the due process clause. And again, this isn't actually before the court right now, but it was part of this case in the lower courts. And during oral argument, again, Justice Barrett at these moments where she seemed sort of surprisingly sympathetic to the plaintiffs, and a lot of her concerns seemed to be about parental rights. So if we lose on equal protection grounds, it is possible this case could come back later. And I want to say one important thing, and then I promise I'll stop talking. I'm not super optimistic about this case. That's not the important thing. I also wasn't actually optimistic about Bostock after the oral arguments, and that ended up being 6-3. So what do I know? But for the first time in history, when the court was discussing trans people, they had to look into the eyes of an actual trans person, Chase Strangio, who argued the case for the ACLU. I, as you mentioned, was inside the Department of Education under the Biden administration at a time when conversations about Title IX were extremely live, and being literally the only trans person in the building. Some of those arguments we won in the room and some of them we lost, but it actually does matter, even if you don't win the immediate battle, that before making a decision that's going to hurt a group of people, they have to look one of those people in the eye. So it is, yes, very possible that we are going to lose. It's possible the court is actually going to set back the movement for trans equality decades, but it's not nothing that they had to look us in the eye first.
Reach. I appreciate that. Thank you. Emily, we've talked a good deal about birthright citizenship, but I don't want to forget about all the other cases where the administration is chafing at the restraints being put on it by courts across the country, including by judges appointed by President Trump himself. Judge Rodriguez in the Southern District of Texas out and out said AEA invocation is unconstitutional, and they've universally held that the president can't end due process. I like to say that the judge in the Western District of Pennsylvania turned her courtroom into a yoga studio the way she stretched to find that the AEA was properly invoked. But we're seeing him fighting against these with Albrego Garcia, with the AEA, with all these other things. Can you discuss how the administration is clashing with the courts and what you expect is coming in these cases, and what haven't we talked about yet in this context?
Yeah, so as much as this is a panel about the Supreme Court, I'm going to have to talk about the administration's enforcement strategy, because in a way, everything the courts are doing is just reacting to how this administration is thinking about and handling immigration enforcement. So I think if you look at a lot of these cases, like you look at the Abrego Garcia case, you look at how the Alien Enemies Act is being used, you look at the moves to put people on Guantanamo for detention, and they said, oh, we're going to have 30,000 people detained on Guantanamo. They've been cycling groups of a few dozen people in and out of there. A lot of what the administration is doing is holding up people as an example. Folks who are visa holders, whose cases have been highly public, these like spectacular instances of deporting folks to prison in El Salvador and then kind of making videos showing all of these men behind the Secretary of Homeland Security and saying, we're going to send you here too if you don't leave voluntarily. This administration wants to have cases and have enforcement actions that are in the media that garner public attention and where they can push the limits in a way that's really, really visible and practical. And so all these cases that are in court. We talked a little bit about the ways that the administration may push back on court orders. Certainly with district court judges, again, they've indicated that they may not follow orders from district court judges. They don't view those as having the same weight as the Supreme Court. We'll see what they do with Supreme Court orders. But I think there are still ways in some of these cases to comply, at least partially or arguably with some of these orders while still getting this sort of spectacular, big public boosts that they seem to want from what they're doing with deportation. So to take Mr. Abrego Garcia's case as an example, the administration has been fighting to avoid having to bring him back, right? Repeatedly, they've clashed with the district court judge who's been hearing the case. They won't even provide information. But what they've also said is even if they were forced to bring him back eventually, and let's say in their minds, that means that the Supreme Court eventually says something a little bit more strongly worded than they said the last time there was an emergency application, they could just deport him again because he has withholding of removal. All that means is that he can't be deported to El Salvador. And so, as they make agreements, potentially with countries like Rwanda, or we heard a rumor about Libya potentially being a place they were going to send people to. Libya and actually denied it. You may have situations where someone like that, they won't be able to send him to El Salvador, which is where he's from, but they'll send him somewhere else, right? And so I think for them, as long as they can make it seem like there's lots of activity and a lot is happening and that they're kind of dominating in this area, you may see them, listen to some court orders, not necessarily push in every case to do things that are violate a court order, but they'll do these things that maintain this perception that the enforcement is really strict, and that they're pushing back on the courts, and like that the president is the one with the power in this dynamic.
Can I just add something to that? Is very similar to the birthright citizenship case, which Justice Elena Kagan kind of broke that down. That seemed to be what the administration was doing with that too. So they're fighting this on the injunction issue, as opposed to on the going straight to the constitutional issue, so that they can try to keep allow this policy to go in place somewhere in some places across the country while this is battled out on the lower level. And still getting those wins. Look at this. When you have your babies here, they will not be granted automatic citizenship. But if they continue to lose, which they've lost universally so far up to now, if they continue to lose, they're not going to seek cert. They're not going to seek cert from the court because they know they're going to lose on the constitutional issue. All they wanted really was to say that they tried to do this thing, they put it in place, and the big bad SCOTUS made them stop if they do. And that sort of is the whole game here. So I think that's exactly what Emily was talking about.
Yeah. And we didn't even touch on it, but I think it's important to note the selective enforcement and the geographical enforcement that they're engaging in. And, what they're doing with the students and using anti-Semitism as a hook to say you can't deport these people. Meanwhile, they're bringing in Afrikaner refugees who are posting all kinds of anti-Semitic tropes all over the internet and saying, no, these people are oppressed, so we are going to give them refugee status in the United States. It's all part of the overarching plan, it would seem. And hopefully we can maybe get into that in a few minutes. We're running up on the time for the full conversation, but I don't want to give short shrift to Mahmoud versus Taylor, Oklahoma versus Drummond, the school religion cases, because those could very much upend the way that schools operate, the way that tax dollars will begin being funneled away from public schools to religious institutions instead. And Sam, your Department of Education, would love for you to hear your thoughts on how this is going to really affect every single parent in America.
Yeah, I mean, I think like Kimberly and Emily have both said, at least some of this is about perspective, right? There's a lot going on, particularly in the education context, where a lot of this isn't legal. A lot of this isn't constitutional. A lot of what's happening in the Department of Education, where they have both cut the Office for Civil Rights by half and weaponized it at the same time, is skirting every statutory restriction that's supposed to be in place. It's not really about that, though. In some ways, it is already having its intended effect, which is chilling. We are seeing more and more schools just take books out of the curriculum preemptively because they don't want to enter the fray at all. We're seeing clinics shut down. We're seeing schools shut down. I also want to say, I think it is worth noting how much of the religious freedom conversation revolves around conservative religions, really sort of belying the idea that we've come to understand religious freedom as pretext for a lot of other things. When we say religious freedom, whose religion are we talking about, right? I'm a lifelong Unitarian Universalist. My faith's central tenet is universal worth and dignity, and if we're theologically opposed to anything, it is discrimination and violence. If I were a parent, could I opt my kid out of English class the week they read Dante's Inferno because we don't believe in hell, or out of history class the day they talk about Ronald Reagan because he was, a raging bigot who let 62,000 people die of AIDS? Or the day they talk about the Holocaust, right? This is a really slippery slope, and there is a real danger that in the name of religious freedom, the court could actually ensconce in the law a preference for some religion over others. A different way of saying that might be that it could be making law respecting the establishment of religion. SCOTUS isn't Congress, but that is getting awfully close for comfort to something that we as a nation are rightly primed, I think, to mistrust.
Yeah, I would agree with that, Sam. I mean, the SCOTUS is not Congress, but the SCOTUS is the SCOTUS. And it is their job. Only 9 people in the world get this job. And it is their job when, as often happens, the Establishment Clause bumps up against the Free Exercise Clause, that they draw the lines that take all the interests into account and come to the most just decision based on that. That's what the founders intended. This is literally their job, but it seems more and more that they're trampling on the Establishment Clause in an effort to expand and expand and expand the Free Exercise Clause to reach all kinds of places where it's not really intended to go. I'm in particular in the Mahmoud case, which I call it the "Don't Read Gay" case about gay books in a school. Um, that case is just so silly because it could have been avoided if just the school administrators had just inserted and left in place an opt out for parents who don't like it if there is a book in their school that they don't want their kids to read, and they took that away, and now we're at the Supreme Court, which now has an opportunity to really do some damage here. But in the case of the charter schools, religious charter schools, I just don't. I mean, I remember long before law school, I think it was maybe civics class in middle school, where we learn that public funding should not go to a religious school. You know, we can have a debate about charter schools, which are independent schools, which get to escape a lot of rules, but still get uh, federal to still get public funding for the schools. But when you add religion to that, there is nothing in the Constitution. I too am a religious person, but there is nothing in the Constitution that guarantees my right to a free religious education for my kids. That's a choice that you want to make if you want to educate your kids that way. I'm not Catholic, but I went to a Catholic school. I got a great education. There's nothing wrong with that, but my parents didn't deserve to get that for free. They paid tuition. And so I think the Supreme Court failing to set those clear lines between the established and the Free Exercise Clause is really, really causing a lot of real world issues, really elevating the evangelical Christianity above all others. Notwithstanding the fact that the main plaintiff in the "Don't Read Gay" case is a Muslim family, Muslim parents, it still does that with an eye on creating a certain kind of America. And I think that's the common theme of literally every case we've talked about today. These are policy decisions about framing what America is, who has the right to be American, and who gets protection and who does not. It's a real nativist term, if you want to look at it that way, and a real, and well, I think it just gobsmackingly anti-trans term. And I think if we stay in the legal minutia, we miss that big point, that big picture, which is so important.
Absolutely. Thank you, guys. We hit all the cases that I wanted to hit, minus a couple, but we only have so much time. So now on to a little bit of Q&A from the folks in the audience. And the first one is, I think the other elephant in the room is that there's been a great deal of consternation regarding the possibility of a constitutional crisis as and when the administration were to blatantly ignore a court order. And some experts have believed that already happened. What is the flashpoint for this issue? Are we in a constitutional crisis already? And how can we uphold the rule of law against an intransigent administration? And I'll let you guys just jump in because that's a big question.
I'll just start, because sometimes it's easier to go first. I think if you think about a house on fire, I think there are hot spots in the floorboards, right? That the constitutional crisis is already starting to, you can smell the smoke. When it reaches a full-on conflagration is when it gets to the Supreme Court. I think the administration is trying to be too cute by half by trying to skirt and flout lower court orders through the appellate process, ostensibly through the appellate process, trying to get around it. I think at some point, the U.S. Supreme Court has to step in and say, this is the line. No, you cannot cross it. And we'll have to see what the administration does at that point. If they cross the Supreme Court's line, then we're at full conflagration. And I think, even given the order last week from the Supreme Court in the AEA case with the detainees, that order basically said, what we said, and don't make us say it again. I say it again, say it on the merits, say it strongly in a way that the administration can't ignore. If you really want to stand up, if you really want to protect your own power and the power of the judiciary, that's going to be the next necessary step.
So I think that's a good way of putting it. I will give you like a pretty academic answer to this question, which is that I think sometimes this idea that we're in a constitutional crisis is not helpful in two ways. I think it's not helpful just as a description of what's going on, because if you step outside of our US context, where we think of ourselves as so exceptional, we worship our Constitution, and anything that kind of changes the way that things are ordered now really scares us. And you look at other societies become less democratic. They've kind of like bend the rules around rule of law. They come back from that sometimes they don't, right? So talking about it as a crisis makes it seem like there's this point where things change and maybe all of a sudden it's difficult to come back from that, right? I think that actually the reality is, yeah, it's going to be harder to get back to the system that we had, but things change over time. Right now, they're moving in one direction in terms of a lot of the norms that we may value being broken, but it's also possible to move them back. So I think that's important just for our understanding to know that there's not this one moment or one crisis point where things change, but that we're kind of on a spectrum, but also just thinking about what that means for us as people who care about rule of law and about our justice system. Sometimes I think when you frame things as a crisis, it makes it seem like there's no way to come back from it. But I think that in any kind of system, whether you're talking about a democratic system, whether you're talking about a non-democratic system and an autocratic system, there are checks on the executive, right? And elites are a check, but public opinion and the people are also a check. And so I don't want the idea that we're in a crisis to obscure that there's still a lot that people can do as individuals in terms of kind of pushing their elected representatives to move where we're at. And that it doesn't just have to go in one direction.
Yeah, Kimberly, I really like your metaphor of the house on fire. And I think that, right, some people in America right now are on maybe different floors of that house, and some people are maybe thinking more than others about when it might be necessary to jump out a window of that house, and are identifying what those benchmarks are, right? What those moments that maybe that is the moment we should rethink some things, or pack a go bag or whatever. I think it's really, really unlikely that the court overrules birthright citizenship, right? But if they did, that would be a huge benchmark. That doesn't have anything to do with birthright citizenship. It has to do with the rule of law. I think the court isn't unaware of this dynamic. They have eyes and ears, and they still seem a little bit, we even saw it this week, a little reluctant to rein in quite as much as they are empowered to do. And then again, like, Roberts did something really rare and issued a statement and said, "Hey, quit this war with the lower judges." It feels like a little bit like Cory Booker's not a filibuster. It doesn't like legally do anything, but it does do something, right? The way people see the legal system and are invested in its legitimacy really does matter, particularly right now, and particularly if we do end up with a house that is on fire. Devin, you're on mute.
Thanks. I want to try and get two last questions in. One, there is a provision in the House Reconciliation Bill that would strip the authority of federal courts to enforce contempt proceedings in the midst of seeing judges prospectively finding the administration in contempt. How concerned should we be that this is pending? And is this not also a serious separation of powers violation by preventing one branch of government from actually engaging in its constitutional authorities? Kimberly, do you want to jump in? You're nodding.
Yes, it is, in a word. Yes, it is. And I think we know exactly why that's happening, right? It's because we are seeing judges like District Court Judge Zinnis repeatedly tell the court that her order to facilitate the return of Abrego Garcia is a real order, and the administration has done absolutely nothing in terms of that, coming up with all of these wild reasons why, including state secrets, in order to do that. And I see, that the next step for these district courts, especially that case, which is just so flagrant, is to say, I'm going to hold a contempt hearing if you don't comply with this order. And you see the Republican members of Congress seeing that coming and trying to stick something in a piece of legislation to buck that. My hair's not on fire about that, because I don't think that would even pass the giggle test in the Senate, but just it gives the game away as to what's going on.
Sure. I do have one last question because, and it's something that you hit on early on, with regard to the Louisiana cases, the redistricting case. As I said, it seems like folks are taking students for fair admission and saying, and running with it to the end of every logical conclusion possible at the end of the universe, but also bringing in that the Eighth Circuit just basically struck down individual enforcement of Section 2 of the VRA. And just wanted to get your, quick thoughts about how the court continues to seemingly take away voting protections across the board at the same time we see an administration that is willing to wipe out the independence of the Election Assistance Commission and the Federal Elections Commission, and what this could portend.
I actually see this case as more of an extension of Shelby County, even more so than the affirmative action case. Although, yes, the affirmative action case is doing much. People are doing way more with that than at the Supreme Court even intended. We have seen, starting with the Chief Justice, a really big skepticism and antipathy expressed toward race-based claims of discrimination based on voting. On a statute, and the fact that we have a long history of discrimination in doing just that, and we're seeing the return of that, does not seem to be a persuasive argument with the majority of this court. I think the court has had in its sights to whittle away or just really dismantle Section 2 for a really long time. I was actually surprised by the Milligan decision, pleasantly surprised by the Milligan decision that actually enforced it. My own thought is perhaps the addition of Justice Jackson, who has a very clear, in my view, originalist view of the 14th Amendment and what it was meant to do and why it is still needed, perhaps was a little help there. But I think that can only last for so long. So yeah, every voting rights case fills me with dread, because I think it's just a way to take away the electoral power that we talked about as a check on government. And it seems that the court is perfectly willing to let that happen.
You wouldn't mean to suggest that the 14th Amendment wasn't intended to be colorblind? I mean, come now.
Yes, right. The only way to end discrimination is to ignore discrimination, right? Yeah.
Exactly. All right. Well, I want to give Emily and Sam a chance to provide any final thoughts because we are coming right up on the noon o'clock hour. And Emily, I know you might have to jump off early, so I'll let you go first.
I would just say the Supreme Court is important, but when we're talking about due process and we're talking about immigration and people's fundamental rights in that area, I think the big question is going to be what the administration does, separate from any kind of judicial review, and how Congress and public opinion react. So look for the detention expansions they're talking about doing. Look for the massive funding for ICE and DHS and the military in the budget, and see what happens with that, because I think that's going to be honestly in some ways more consequential than anything that happens at the Supreme Court.
I will just say very briefly, and I realize I am in the presence of a law professor, and so this is a completely different tack. But in the world of right, and when we're talking about the law and we're talking about the world of civil rights, we are also sort of inherently talking about approaching a system that was not designed to protect us. It is only very recently that we found safety in or protections in or any sort of justification for being. And there is this, I think, opportunity to remember what was fought for, remember our roots. And I think it's not an accident that we're seeing a lot of mutual aid networks pop up here and there, that we have always looked to our own communities for legitimacy. And sometimes the Supreme Court has been on board with that, and sometimes the government has been on board with that, but more often than not, they haven't. And we are still here, and we are still going to be here.
Absolutely. I mean, we forget that the Civil Rights Act only happened 60 years ago, that LGBTQ protections have only come up in the last 15 to 20 years, and that women could only get their own bank accounts in 1972, 1973. So all these protections are still relatively new, and I hate to see the retrenchment of the bad old days that seems to be coming with some willing participants in multiple branches of government. So we are at 12 o'clock. I want to thank you all for your incredible insights. And we will be on the clock for the next 6 weeks, watching what's coming down, keeping everybody in the audience aware. Follow Kimberly and listen to her podcasts. They are phenomenal analyses. As much as we'd like to have her on every week, we don't do that, but she is available. And Sam, thank you so much for all the work that you've been doing, and thank you for coming on. And that is it. Thank you all for being here, and take care.